You wake up one morning, pour your coffee, look out your back window, and your jaw hits the floor. The 200-year-old oak tree that has stood in your backyard since before your grandparents were born. The tree that survived 2 world wars, 7 presidents, and 3 generations of your family. The tree that professional arborists estimated was worth, and I am not joking, $1 million. Destroyed. Chopped down. Hauled away like trash. And you know who did it? HOA, your homeowners association. The same group of people who send you a violation notice if your mailbox is 2 inches off center, who fine you $50 for a garden gnome. Those people took a chainsaw to a national landmark growing in your own yard. And here's the part that made my jaw drop when I first heard this story. They had absolutely no idea what that tree was worth. But they were about to find out. Smash that like button, subscribe to Neighbor Wars HQ, and stay right here because this story gets wild. Welcome back to Neighbor Wars HQ, the channel where we dive deep into the most unbelievable, jaw-dropping, absolutely unhinged disputes between neighbors, HOAs, and homeowners who refuse to back down. I'm so glad you're here, because today's story is genuinely one of the most shocking cases we have ever covered on this channel. Before we get into it, if you're new here, hit that subscribe button right now and ring the notification bell so you never miss a story like this. We drop new Neighbor War content every single week, and trust me, you do not want to miss what's coming. Now, let me paint you a picture of how this all began. Our homeowner, let's call her Margaret, had lived in her home for 23 years. She purchased the property specifically because of the land. Rolling acres in a quiet residential community in the southeastern United States. And at the center of that property stood what neighbors, historians, and arborists all agreed was an extraordinary specimen, a 200-plus-year-old southern live oak with a canopy spreading nearly 90 feet wide. This wasn't just a tree. This was a landmark. Local historians had documented it. School groups had visited it. It was even featured in a regional newspaper article back in 2009 as one of the most remarkable trees in the county. And Margaret? She loved that tree with all her heart. She'd had it professionally assessed twice. She knew exactly what she had. She had documents. She had insurance riders specifically for that tree. She had done everything right, which is what made what happened next so absolutely devastating. It started as so many HOA nightmares do with a letter. Margaret received a notice from the Sunrise Pines HOA board stating that a routine landscaping inspection had identified several trees in violation of community aesthetic standards and that the HOA reserved the right to address these violations to maintain property value and neighborhood uniformity. Now, here's where you need to pay close attention, because this detail matters enormously. Margaret's oak tree was on her property. Not common ground, not a shared easement. Her land, her tree. She called the HOA office. She spoke to the property management company. She sent a written response clarifying that the tree was not subject to HOA jurisdiction based on the CC and RS. Those are the covenants, conditions, and restrictions that govern what an HOA can and cannot do. And for 2 weeks, silence. Margaret thought the matter was settled. It was not settled. On a Tuesday morning in October, Margaret left for work at 7:15 a.m. At 7:45 a.m., an HOA contracted landscaping crew arrived at her property. By 11 a.m., in less than 3.5 hours, her 200-year-old oak tree was gone. Nothing left but a stump and a pile of sawdust where 2 centuries of history used to stand. Her neighbor, who witnessed the entire thing, said the crew didn't even hesitate. They just rolled up, fired up the chainsaws, and started cutting like they had every right in the world. When Margaret came home that evening and saw what had happened, she described it as feeling like someone had torn a piece of her family out of the ground. She sat down in her yard, next to the stump, and cried for an hour. But Margaret? She wasn't just heartbroken. She was furious, and she had receipts. The very next morning, Margaret was on the phone with an attorney. Now, here's where this story transforms from a tragedy into something that made HOA boards across the country sit up and take notice. Margaret's lawyer immediately requested all documentation from the HOA, their authorization, their permits, any communications about the tree removal decision. What they got back was frankly embarrassing. There was no permit. There was no formal board vote documented in the meeting minutes. There was no legal notice given to Margaret as required under state law. And perhaps most critically, there was no arborist report, no heritage tree assessment, nothing to suggest the HOA had done even the most basic due diligence before sending in a crew with chainsaws. They just did it. They decided a tree on a private homeowner's property didn't look right to them, and they removed it. Without permission, without proper process, without having any idea what they were destroying. Margaret's attorney brought in 2 independent certified arborists to assess the damage and calculate the value of what was lost. Their findings were entered into the legal record, and they are staggering. The tree's replacement value based on its species, age, size, historical significance, and environmental contribution was assessed at $875,000 to $1. $2 million. When you factor in the documented historical significance and the impact on Margaret's property value, experts put the total damages figure at over $1 million. $1 million. For a tree the HOA apparently thought was just kind of messy. The lawsuit was filed within 30 days. The causes of action included trespass, destruction of property, negligence, violation of state tree protection statutes, and intentional infliction of emotional distress. The HOA's property management company? They ghosted. Their attorney initially sent back a letter suggesting Margaret was being unreasonable and that the HOA had acted within its authority. Margaret's legal team responded with 47 pages of documentation, expert affidavits, and a very clear message. See you in court. I want to be very careful here because legal cases are nuanced and outcomes vary by jurisdiction. But what I can tell you is what happened in this specific case, and it is deeply satisfying. 14 months after that October morning, when her tree came down, Margaret reached a settlement with the HOA and their landscaping contractor. The terms were confidential, but her attorney, in a public statement, described the outcome as fully compensating our client for the irreplaceable loss she suffered and sending a clear message that HOAs cannot act as unaccountable authorities over private property. The HOA board saw significant turnover in the following election cycle. New bylaws were passed requiring written homeowner consent and a certified arborist review before any action could be taken regarding trees on private property. The property management company lost the contract, and Margaret? She used part of the settlement to plant a grove of young live oak trees on her property. She says in 200 years, someone else will get to love them the way she loved hers. If that doesn't hit you right in the chest, I don't know what will. Before we wrap up, I want to give you something genuinely useful because this story isn't just dramatic, it's a real warning. First, know your CC and RS. Read them. Understand exactly what authority your HOA has and, more importantly, what authority they do not have over your private property. Second, document everything. If you have a tree, a structure, or any significant feature on your property, get professionally appraised and keep that documentation somewhere safe. Third, if your HOA sends you a notice about anything on your private property, respond in writing immediately and consult an attorney before you assume they have the right to act. Fourth, most states have tree protection statutes that impose significant liability for the unlawful removal of mature trees. Know your state's law. HOAs are not above the law. They are not all-powerful. And as Margaret's story proves, mess with the wrong homeowner, you might be writing a check you can't afford. If this story made your jaw drop, and honestly, how could it not smash that like button right now? It literally takes 1 second, and it helps more people find stories like this. Subscribe to Neighbor Wars HQ if you haven't already. We are building the biggest community of people who believe in standing up, knowing your rights, and never letting a bully in a polo shirt and a clipboard ruin your life. Drop a comment below. I want to know, have you ever had an HOA overstep on your property? Or do you have a neighbor war story that you think deserves to be featured on this channel? Tell me everything. I read every single comment. And if you want more stories just like this one, check out the playlist linked in the description. We've got dozens of cases where homeowners fought back and won. I'll see you in the next one. Stay informed, stay fired up, and never, ever let anyone bulldoze what's yours. Neighbor Wars HQ.